Hello and welcome to the ICC Annual Arbitration and ADR Conference. We're just starting in a few seconds. We're just letting people log on to the system. Thank you. Hello, good afternoon, good morning from wherever you are joining us from. This is the last session of our three-day conference. I hope you've enjoyed the last 3 days as much as we have been organising it all. It's been fantastic to see so many people joining us from 45 different countries from around the world. It really has taken a different leap into the world of arbitration and international arbitration as well. So thank you very much. Without further ado, I'm delighted to present Cristiano Zanetti, who will be our moderator for the next session. ICC Brazil kindly offered to do a session with us, and it's great to have them on board. Cristiano is the Vice Chair of the Arbitration ADR Committee over in Brazil. Over to you.
Thank you very much. I would like to start by thanking ICC United Kingdom for inviting us to take part at this prestigious ICC UK Annual Arbitration and ADR Conference. It was a generous offer, actually, and we gladly accepted it. Speaking on behalf of ICC Brazil, we do our best to keep the high standards that were set by the previous webinars and roundtables. As you may have seen in the program, our webinar will discuss the increasing participation of Brazilian public entities in arbitrations. It poses to us all an important question. With the rise of such a big player, is arbitration still the game that we are used to do? To debate such a relevant issue, I have alongside with me Ms. Maria Claudia Prokopiak, partner of Prokopiak Arbitration and International Arbitrator based in London and in Rio. Arthur Watt, Brazilian federal attorney, currently working from Brazilian Petroleum Agency. And Cesar Pereira, partner of Justin Pereira, Oliveira and Talamini, an international arbitrator based in São Paulo. My name is Cristiano Zanetti. I am the Vice Chair of Brazilian National Committee for Mediation and Arbitration, and will be my privilege to moderate this webinar. Before moving on, I would like to encourage the audience to put forward any questions they may have to our panelists. I'm sure they will be happy to take those questions at any moment of our webinar. That being said, let's move forward. The first question that I would like to discuss today with our guests is the following. Is it correct to consider that Brazilian legislation regarding public entities is arbitration friendly at this juncture? Saying that in another fashion, are there any remaining concerns after the legislative changes that occurred in 2015 and 2021 regarding the circumstances? I would like to ask Cesar, if I may, to start answering this one, because as an expert in public law, perhaps he would start us to assess this discussion. Cesar, over to you.
Thank you, Cristiano. Well, it's a pleasure and an honor to be here sharing this panel with you, Maria Claudia, and Artur. And I thank ICC UK and ICC Brazil for the invitation. Well, very briefly here, as it's necessary for our purposes, Brazil has a very well-established legislation in terms of arbitration, and that has been considered since the enactment of our arbitration law in 1996, that has been considered by courts generally enough to allow public entities to take part in arbitration. We had over, especially in the beginning of the years 2000, we had several important court decisions acknowledging this possibility. without reference to any additional legislation other than the Brazilian Arbitration Act. But the fact is that when public entities, and Artur will certainly be able to address that even more precisely, when public entities enter into arbitration, the government officials must make a decision. The natural way to resolve disputes would be to just let it go to the judicial power, right, to courts. So they do have to make a decision. And in order to allow or to grant public officials more certainty in terms of doing the right thing, it's useful for them to have clear legislation allowing that option for arbitration. And so when Brazil started a great move toward modernization of its administrative structures in the 1990s, that was coupled with a series of laws expressly allowing public entities to adopt arbitration. That was true in many regulated sectors, in PPPs, in government concessions that happened around 2004, 2005, and all that led to a great awareness of the possibility of arbitration in public entities' contracts and in transactions. As you mentioned in your question, in 2015. The Arbitration Act was indeed amended to include expressly the possibility of arbitration involving state parties, which, as I said, was already acknowledged by courts before that. So that was merely a confirmation. We had, well, after that, obviously, public entities grew even more confident of this possibility, and arbitration involving state parties became even more common. Now, I think a very interesting development that we had this year, 2021, was the enactment of our new public procurement law. And in this new public procurement law, again, in a great part, it confirms this possibility of arbitration involving state parties. It also adds some important novelties. It's the first general law that allows dispute boards in government contracts, for instance. It also promotes mediation as an ADR in government contracts. But I think the most important aspect is that the public procurement law is every government official's everyday law. It's the first thing they read, and it's very important that in that law, the only one they will read, if they ever read one law, in that law there's a chapter about the use of arbitration in government contracts. And so I think that was a very interesting development, and I'm very optimistic about that.
So you would say that at this point, there should be no doubt regarding the possibility of public entities deciding their conflicts through arbitration. Is that correct?
That's correct. There hasn't been doubt about that for several years. And so now what we see is a growing enthusiasm, really, of the public administration with arbitration, which is reflected in these series of laws and executive orders.
Perhaps this would allow us to move to our second topic, and this one is related with numbers. We know that amongst the ICC cases filed in Brazil to this date, a staggering number of 25% at least involve Brazilian public entities. In total, we have 38 different Brazilian public entities currently involved in cases managed by ICC here in Brazil. I have a question regarding these numbers. I was asking to myself whether this is already plenty or just the beginning. In other words, how often do public entities choose arbitration instead of state courts? We understand there is a trend in that direction, but how important is such a trend? And what sorts of controversies public entities usually submit to arbitration? Arthur, I think you are the most qualified person in this virtual room to answer this question. So would you like to share with us your experience regarding those questions? I think you are on mute, I'm afraid.
Good morning to everybody. It's a pleasure to be here at this panel with all these great professionals, and I thank ICC UK very much for this opportunity. Well, I think the arbitration with public entities in Brazil is already a reality. It is already growing, and for our experience in the judiciary system, the litigation with the state and public entities is a very large chunk of our litigation in general in Brazil. So I think in arbitration, it's no different. It's a big field and a growing field. Of course, we have initiatives to resolve consensually a lot of disputes, but I'm an arbitration enthusiast, so I feel privileged to work in ANP, which is the oil and gas agency in Brazil, because the oil and gas sector is so arbitration friendly and used to arbitration that we in ANP, we were the first and the biggest entity in arbitrations regarding public entities. And I'm saying this just making a difference. We are not. I did some research and numbers to show you, but I just want to say I'm talking only about the real public entities, meaning not including the companies owned by the government, because these arbitrations that these companies may participate, they are not so public as we're going to discuss the public nature of these arbitrations, but they don't go this far for companies owned by the government. So I'd like to share, since we are talking about numbers, I would like to share some numbers with you. This is from my experience working in Brazil in arbitrations. Here we have some, yes. This is a chart that I made with all the finished arbitrations involving federal public entities in Brazil, excluding companies, of course, as I said, and excluding states and municipalities, which they are already have some arbitrations. So as you can see, most, like 80% of these finished arbitrations, they involved ANP, which is the entity that I represent in arbitrations with my team. And these arbitrations, and we have two other finished with other entities, which, by the way, I'm starting to consult with, like give some help, since our experience in ANP is greater, and since 2006, for instance, I started in 2010 in ANP. So we have a lot of finished arbitrations, sometimes with settlement, sometimes with total success from the public entity, And one of them, the first one was like claims partially successful. But what I think we're discussing further the outcomes, but as you can see, in general, the public entities, the federal public entities, are doing very well. I mean, of course, we're not ever going to win all of this, but we can say that the public sector in Brazil is a player and is doing quite well, and it's prepared to deal not only to put the arbitration clauses, but to actually work in these cases as well. So this is 10 finished cases, which eight are with ANP. But just now, in ANP, we have 12 other ongoing arbitration cases. And I think other entities together, they have something like 8 ongoing arbitrations as well. So I think these numbers show that this is already a reality, and we are already in the game.
Do you think it's correct to assert that this is a very representative sample of the current situation when we consider the whole of the public entities in Brazil? I mean, you're obviously talking from your experience regarding ANP, and we saw some figures. If I'm not mistaken, there was one arbitration of $11 billion, another one of $1 billion. So we're talking about important, relevant disputes. So would you say that those disputes are representative of the current situation regarding the administration, the Brazilian public administration as a whole? Would you confirm that?
You mean in terms of value at dispute?
No, I'm interested more at this juncture to discuss the trend. I mean, ANP is apparently very comfortable in setting their its disputes within the framework of arbitration. Would you say that it's a general trend, or ANP is perhaps a bit more forward towards arbitration than other public entities?
I should say, yes, this is a trend, but it's a trend that ANP started. Why? Because in the 90s, only a few agencies had express legal authorization to put arbitration clauses. So the oil and gas agency, ANP, the telecom agency, so they started to put this. But ANP is the bigger one and have many contracts, like oil and gas leases that they're in the hundreds. So we started the trend. And after the legal changes that Cesar was commenting on, especially in the year 2015, which they gave a broad authorization. So this trend started to spread out, and it's still incipient. We have few entities already doing the arbitration, but we have a lot of entities putting the arbitration clauses, especially on the concession long-term contracts. Of course, they're not for everything, for buying, for sales agreements or anything, but in the concession agreements, long-term agreements, it's already an established trend, I would say.
So we are a sort of pioneer
yeah,
in the field of arbitration, so, if I may say
well,
so.
for an arbitration enthusiast, I'm very privileged, because since we started in ANP, the other entities that started to arbitrate, they started to call me like an informal consultant. So I'm pretty much having some degree of involvement in all these cases, as at least consulting for the colleagues who are starting to see these arbitrations getting started. So it's pretty nice. And I should say, since they're public, One of the cases I put here, the case number 9, I can project again later, involved a panel that Professor Zanetti was on it, and it was a pioneer case involving the government, the Brazilian government, like the federal government itself, not an agency. And it was a very important and big case. So it's a trend that's getting established.
Well, thank you for mentioning the moderator. I'm not sure if I'm allowed to speak about this case, not only because I was involved with, but I'm just supposed to moderate today, so I will try very hard to not comment on this. But we already have a question from the audience. This question comes from Ms. Shobana Ivor, who happens to be barrister and arbitrator in London, I believe. She is asking, and perhaps I would direct this question to you, Arthur, whether there are already climate change disputes regarding the public administration in Brazil. Are you aware of any disputes that discuss climate changes at this moment?
Well, climate change specifically, we don't have any cases related. I don't know of arbitration clauses or if they are going after the dispute. This is very new in Brazil, so we don't have specific ones. But I should say that ASG cases in general, we have some of them in A and B, meaning it is very interesting cases that sometimes you have a contract with A and B, and oil and gas concession agreements, and in some specific cases, in very sensitive areas, the concessionaire, the operator, couldn't get the environmental licenses for drilling. Sometimes they're refused by the environment organ in Brazil, or sometimes we get lawsuits from associations or representatives stopping this. And so we did get some cases that got to arbitration, disputing how this environmental obstacles should be treated in the concession agreement. So we do have some ASG cases, we could say.
I would say that we'll probably have some more in the near future, but let us see. It's always hard to guess. I would like to ask whether Maria Claudia would comment on this, because I'm curious whether the international character of the contracts are relevant in any fashion to arbitrations involving public entities. And since Maria Claudia is perhaps the more international member of our panel, living in 2 cities at the same time, probably not traveling on and off much these days, but would you like to comment on this, Maria Claudia?
Thank you, Cristiano, and it's a pleasure for me to be here today, and to thank the ICC UK and the ICC Brazil for the invitation. Now, with regards to the question, I think it does. I think it absolutely plays a role when it comes to, choosing arbitration instead of state courts. If you have a foreign contractor, the chances that arbitration will be chosen as the dispute resolution mechanism is very high for obvious reasons. But I think that the most interesting aspect of this issue, when we look at what type of disputes or controversies that state entities in Brazil are submitting to arbitration, we know that the nationality of the contractor is not necessarily a determining factor. And what I mean by that is that state entities in Brazil, they have no issue in arbitrating their disputes with their own nationals. And this is something that it's not that common in other countries. And here I'm not talking about, the foreign investor who has to structure its investments through a national vehicle. And I'm sure Arthur will be able to explain to us a lot more about that. But I'm really talking about the national domestic investor. If you look at certain big infrastructure construction projects, for example, in Brazil, you will see more often than not that the construction company or the concession holder is 100% Brazilian. And you have this 100% Brazilian contractor who will sign a contract with the local authority, and that contract will foresee arbitration as the dispute resolution mechanism. So to go back to the question, if there is an international interest, then the chances of the contract to provide for arbitration are very high. However, I would dare to say that in any public-private partnership in Brazil, irrespective of the nationality of the contractor, disputes not only can be submitted to arbitration, but probably will be submitted to arbitration. And I think, at least from an international point of view, that is the interesting point in this discussion.
If I may say something from my experience, sometimes we have arbitrations that appear to be national arbitrations because the companies, they are somehow established in Brazil, but the reinterest, the investment comes from other countries. And I believe there's a reason to that. And even in these cases, whether being national cases, I would say authentically, or national cases for other purpose, we have experienced a lot of cases dealing with disputes regarding public entities as well. So perhaps Arthur could illustrate us why do we have in some situations a foreign investor, but in arbitration we have a Brazilian legal entity? Why is that so?
Well, thank you for your question. I'll speak in my point of view as dealing with A and B. First, the first thing I like to say, as Maria Claudia was commenting, from our legal perspective, there's no difference in arbitrating, accepting an arbitration from Brazilian entities, companies, or foreign companies, or a Brazilian company controlled by a foreign investor. This is no difference at all. But what I could say is that the demand for we having an arbitration clause is higher, way higher, when you have a foreign investor, as in the oils and gas sector, for the many reasons that foreign investors demand arbitration. So these clauses, they started very early in A&B history, of course, because of this demand from foreign investors. But interesting enough, that is a comment I'd like to say, the people who actually use the clause, I mean, they start arbitrations. In our history, it's like 100% entities that are Brazilian and controlled by Brazilian investors. We didn't have foreign investors, even through their Brazilian entities, starting an arbitration with ANP or other federal organ yet. From all these arbitrations, they're all started with like Brazilian controlled companies, with one exception, that it was a consortium, a joint venture, that the Brazilian company was majority, and you have some investors as minority stakeholders, with this single exception. All the others, it was 100% Brazil. So I think the foreign investors, they want the security to feel safe as having the arbitration clause, but I think the Brazilian parts, they're more likely to actually use it when it's not like an expropriation case, which we didn't have at all in Brazil. I think the foreign investors, they keep this safe place for real big serious questions that we didn't have yet in Brazil.
It's a peculiar situation, I believe, as Maria Claudia just said. Time is running fast, I'm afraid. So I think we should move forward to discuss our third topic. We have 6 in the program. Hopefully we get there. And this one regards the difference in terms of procedure and practice. My question is the following. Is it any different to litigate in a case involving public entities in comparison with cases involving private entities? I will stay with you, Maria Claudia. Would you be so kind to share your experience with us?
Sure. Well, when you talk about differences, and the question that you put is there a different way of doing arbitration if a Brazilian public entity is involved? And I would say yes and no, and I will try to explain myself. I think that more than real differences in the proceedings, we have certain specificities. So just to give an example, the choice, starting with the choice of the arbitral institution. Now, in Brazil, be it on the national level or in some states level, you have specific legislation that provide for the registration of arbitral institutions for them to be eligible to administer cases with the state or public entities. Now, sometimes the way the arbitration clauses are then drafted, they leave the choice of the institution amongst those registered to the claimant, to the party initiating the arbitration, which is normally the private contractor. So the private contractor is in a good position, so to speak, as they will have the final say on the set of rules that will apply. Now, one could question whether this registration is necessary. With the reform of the Arbitration Act in 2015, as Cesar was mentioning, it has basically been laid down in statutory law, something that in practice was already pretty much consolidated. Public entities in Brazil, they arbitrate. They used to do it before, and they keep doing it now. So this reality could lead one to conclude that maybe this type of additional requirement, so that arbitration can be agreed in contracts with the state, is unnecessary. But I think that more than analyzing whether these measures or any of these specificities are necessary or not, we should look at the objectives sought, by these measures. Now, if the purpose of the measure is to provide security to the public administrator or the public official responsible for negotiating the contract and agreeing to arbitration and choosing an institution, so that there's no hesitation in their part, given that those institutions have already been pre-approved by the state in a way, then that measure will have the consequence of facilitating the inclusion of arbitration clauses in these contracts and not the opposite. And I think that, and I was trying to identify these differences or specificities. And I think that every time that we identify one of these specificities of arbitrating with a public entity in Brazil, their goal is to facilitate arbitration. Now, in terms of the procedure itself, the legislation provides for other requirements that should be included in the arbitration clause, such as arbitration in Portuguese or seated in Brazil, which honestly doesn't sound unreasonable to me if you want to do business with the Brazilian state, and it's not a novelty of Brazil. This is done by many other states. And their goal is to facilitate the submission of the state dispute to arbitration. We can think of other examples, and Arthur can explain to us a little more about that, but how advances on payments are made throughout the proceedings, given the difficulties of the state to incur in expenses that haven't been budgeted. Those are very pragmatic issues, and they have the solutions found to these issues have been very pragmatic as well. So in a nutshell, I think I would say yes, there will be some specificities in these proceedings, but they don't create, of course, any imbalance between the parties. And the most important point, I think, when we look at them, is that their raison d'etre is to facilitate that disputes with the state be submitted to arbitration and not give any kind of advantage or special deference to the public entity. The way I see it is a matter of understanding the realities under which public entities operate, and then trying to adjust the arbitration mechanism and make it compatible with that reality, so that those operators can be part of, the game, if we call it that way.
Oh, I would say that apparently those are all reasonable rules. You can understand that very quickly, not very surprising, not very complicated to deal with. But perhaps I should address a topic that is critical to most public entities around the world: costs. Because it's much easier for a private entity to decide how to spend their money. We cannot say the same thing about the state. So I'll bother you once again, Arthur. You're our insider here in the panel. How about the costs? Is it an issue for public entities while settling their disputes through arbitration? Have you already figured out how to do it? Are there any specificities that you like to share with the audience? Please, over to you.
Well, first of all, I would like to say that when representing a public entity in an arbitration and even advising some colleagues on that, I always try to put in a way that the public entities should act as much as possible as a private entity. I mean, we don't ask for special treatments on the merits or anything like this. But of course, in the procedure, there are some things that are very different and should, as Maria Claudia said, to bring the public entities to the arbitration, they should be taken into account. And one, or the main one, the main thing is of course the costs. Not specifically the overall cost, because we understand that arbitration, when you consider the time frame and the values at dispute, it's not particularly expensive. I mean, if you have a $10 billion dispute, the costs can be minor compared to what's in dispute. But the way, as you said, for the public entity to actually open the wallet and advance costs and this kind of thing, this is very complicated. And unfortunately, at first the institutions were not prepared to deal with this. Even as we said that we can't make advancements, they keep putting the invoices to pay in 10 days and things that are not imaginable in public entities. So we started to address this in the arbitration clauses. So we did change and put some specific demands in arbitration clauses, but our first cases, we still have cases with the old clauses that didn't address that. But I think that they're starting to understand that it's not possible to make these advancements. We are not hiring external counsel, so the in-house lawyers, which like me and my team are representing the public entity, we can't choose specialists to hire to make expert witness testimonials. So we prefer the expert witness chosen by the tribunal that we can just ask the public entity specialists to comment on, because they can't be expert witnesses like independent ones. So this kind of thing, they're starting to get used to it. and we try to address in the arbitration clauses. We are developing pretty not long but pretty like detailed clauses that address these specificities, and the market and the institutions are starting to get used to it.
From experience, I would say that the latest clauses are far better than the older ones. They're easier to deal with. Sometimes the older clauses, they create some problems regarding, for example, technical evidence. So that could be a deadlock, and I think it's no longer in place. I think the clauses, at least the clause that I see in agreements involved with public entities, they're more suitable to the situation of the state, which obviously is particular from many points of view. I'd like to discuss perhaps a bit complicated topic, and I would like to address the next question to Cesar, who has been so quiet so far. So I'll give you the floor to perhaps a difficult one, because as a professor, you should deal with difficult questions. So I just find it appropriate to ask this one to you. So my fourth topic here is publicity. The arbitration law simply says that arbitration proceedings must respect, arbitration proceedings, I mean, involving public entities, must respect the, between commas, principle of publicity. And that's it. So this has been repeated in the latest laws, but that's it. That's not very, I would say, very precise. It's a bit vague, if I may say so. So my question to you is a simple question, perhaps not it would receive a simple answer. What does it mean exactly? Who's responsible for rendering effective this principle of publicity? Cesar, please enlighten us about this topic.
Okay, well, I'll try. First of all, I just wanted to make a comment about what Artur and Maria Claudia were saying. In a way, it has to do with the idea of publicity. ANP and Artur specifically were pioneers also in something else. I think it was in 2018, ANP held, or 17, held a public hearing to discuss precisely, among other things, the draft of their new arbitration agreements, the arbitration clause that they were going to include in their concession contracts from that point on. And so that gave many players, many stakeholders in the arbitration community the opportunity to go there and address Artur and his colleagues directly about our concerns. And many of those concerns were included in the arbitration, in the new arbitration clause. That was actually a model for other agencies. And Artur mentioned that he's being called often to be something like a consultant to other Brazilian agencies because of that. In that transparency, that openness to discussion when drafting the arbitration clause was remarkable, and was a very good example for other Brazilian entities as well. And if going back specifically to the issue of publicity, Brazilian Constitution provides that the public administration is subject to transparency, to publicity, and that premise was already accepted and incorporated into arbitration practice even before 2015, when that was included specifically in our Brazilian Arbitration Act, in the statutory law, right? And so that was already recognized that arbitration with the state needed to be public somehow. As Artur mentioned, the public administration has different forms, and sometimes it's a government department, sometimes it's a government-owned entity. They are subject to different levels of publicity, in general, and that's true also in arbitration, right? And in 2015, we included this phrase specifically, and then we had to deal with that, right? We had to understand what that meant. It's easier to understand what that does not mean. It does not mean that that arbitration must be as public as the as litigation, and that we should, as we do in litigation, we should publish every procedural order in an official gazette, for instance. That's not the case. What has been maybe some type of compromise solution is something that's included in the rules of many arbitral institutions, which is offering, in general, information about the existence in basic characteristics of the arbitration procedure on websites or in publicly available platforms. However, assigning to the public entity that's part of the arbitration the actual duty to comply with publicity. And I think that makes a lot of sense, because it is actually the public entity that is accountable for its activities, and that is that must act in a public manner toward towards society in general, right? And it's not something within the procedure, but it's the beneficiaries of that publicity is society in general, and that is the role of the public administration. But as I'm sure Artur will be able to comment on that, several arbitration clauses issued by Brazilian entities have started to provide for the arbitral institutions to take care of that publicity. I think that's a possible arrangement. It's in a way, it's a contractual arrangement with institutions, but the basic duty of publicity, I don't think it can be assigned to anyone except the public entity involved in arbitration.
Well, if I may, small personal comment here. I remember the first case of the federal administration, which was involved in. Artur was kind enough to comment it. There was an issue because it was the first time. So what should we do about this rule? And by then, the institution decided itself, okay, we would put everything online. So with the agreement of the parties, of course, we're putting everything online. So if you Google it, you'll find it. But nevertheless, we have received like dozens of requests for several entities of public administrations require information about that case. We provide them anyway and say, okay, and you can also Google it. But it was never a problem, at least in my experience, from the perspective of the public entities. It was more understanding how it should work. We still have two topics, and perhaps I should deal with them simultaneously because we do not have too much time left. And our final topics would be enforcement and the overall reaction of public administration regarding decisions in arbitration proceedings. So my first question, I will stay with you, Cesar. Do you believe that to an extent, enforcing a decision against a public entity is any different from enforcing a decision against a private entity? That's my last question to you. And if I may, I'd like to address my final questions to Artur and Maria Claudia as well. That's for you, Cesar. I hope you have understood this question. And to Artur, I would like to ask perhaps a more bluntly questions. What happened when state entities lose? Do they challenge the arbitral award before state courts? And finally, my other question will be addressed to Maria Claudia, and I would like to know if she believes that the scrutiny provided by the ICC rules reduces the chance of winning a challenge against an arbitration award involving a public entity. I put the 3 questions, and I'm trusting my panelists to respect the time. So, Cesar, if you may start, please.
Okay. Well, very briefly. Enforcement regarding public entities can take enforcement of money awards, money judgments or money awards against public entities can take 2 basic forms. And that is also related to that difference of formats of public entities. Government-owned companies will be subject to the same type of enforcement of private parties, and government departments. The administration itself is generally subject to a procedure that requires submitting the money judgment to a court, and including that judgment in the entity's next year budget for payment. And so that's pretty much what happened with the federal government. And so if you get a judgment this year, you will be paid normally by the end of next year. What happens, and I think that's an interesting aspect, is that and it has to do with something Maria Claudia mentioned before. We have this trend of domestic arbitration with the state in Brazil, involving usually domestic parties. And we don't have treaty arbitration, right? Treaty-based arbitration. And so in many cases, what plaintiffs seek in an arbitration against the state in Brazil is not a money judgment per se, but for instance, the rebalance of an ongoing contract. And so many times the enforcement of that award will not be a simple money payment, but will be in a way an order for the government to take some measures within the contract and sometimes incorporate that right that was acknowledged to the concessionaire, for instance, into the contract. So I think that's a difference in terms of enforcement. And just a final comment before we move to the challenge issues. If we look at enforcement also in terms of the actual chance of getting the result you want from arbitration, and so that has to do a little with challenge. We see in Brazil a very low, and I believe compatible with international practice, rate of success in challenges. And well, there are several studies about that, but there is one that was conducted in Paraná, in my my state, my home state, that looked at 174 state Court of Appeal judgments, and only in 12% of those cases, those challenges were accepted, and normally for reasons that are internationally accepted as well, like a breach of due process, things like that. And so I think in terms of enforcement, we also have a very friendly system in Brazil. Thank you, Christian.
Thank you. Let me see whether Arthur agree with you.
So yeah, I totally agree. And going very briefly back to this chart. So this is a study I did. We didn't motion to vacate any decisions. Of course, we are this federal public entities. We are losing very little, so we don't have a big sample to study. The only award against us was this number 1, which by coincidence I was not there yet. It was before 2010 when it started, but that's just a coincidence. But we didn't, it was partially successful, the claimant's claims, and we didn't motion to vacate. We had in this number 6 just an anti-arbitration that we did before the award. It was ended with the settlement, but before we tried to dispute if this could go to arbitration, and it was rejected by the courts. And we had in the number 9, which is not A and B, but the court battle is not over yet, but the claimant tried to motion to vacate, and they were not successful. But in all the other cases, we didn't have this motion to vacate. So as I totally agree, and very, very quickly, because of the time, that this is not out of the curve. Of course, there's the human nature to dispute some decisions that they don't agree. But as I try, we have, and one big question is the public attorneys use to arbitration practice? I would say that in general, no, but the ones that are getting the studying arbitration and getting specialized in it, they are observing this different way of litigating with award that's not subject to review, only annulment in very specific ways. But I think the public sector and the public attorneys, they're starting to get used to it. It's not easy. It's a lot of people, but we start to share all this understanding.
Thank you. I'm glad you both agree. That would be perhaps a bit disappointed to Cesar if you say something different, but that was not the case, fortunately. So, Maria Claudia, how about the scrutiny? Is this an advantage? Is it not relevant? What are your thoughts on this?
Thank you, Christian. I think that the very short answer is yes, the scrutiny provided by the ICC court reduces the chances of, in my view, any kind of award being annulled, not only awards with public entities involved. But I would dare to say, and Artur can correct me if I'm mistaken, but I think that considering that arbitral awards are not subject to any kind of appeal, the fact that the scrutiny exists in the ICC system would give the public entity a certain degree of comfort, I would imagine. Especially when we think that it is the ICC court's practice to submit awards involving states and state entities to its plenary session for approval, when all of the court members are present, as opposed to the committee sessions when you have a reduced number of court members. So you would have over 100 specialists reviewing and scrutinizing that award. Now, considering the limited grounds in which an award can be annulled, I do think that the ICC scrutiny provides a kind of a seal of approval and a recognition that that award complies with at least the ICC standards. Now, does that mean that an ICC award will never be annulled? Of course not. But the scrutiny provides for this extra layer, I think, of protection. And I do believe that in general, it improves the quality of the awards, and that does enhance, the enforceability of these awards as well.
Thank you. In my opinion, if I may say so, there has been a bit of a reaction about challenging awards. That's natural that some awards would be challenged. That's also natural that some challenge will be granted. But we have to think in big numbers. We cannot say, oh, there was one award that was challenged, and this is a huge problem. That's overreacting to something. There might be issues, but generally speaking, we do have a lot of cases in Brazil, and that's a growing number of cases. That means more challenges, but that not means that proportionally there are more challenges than there used to be. So we have to consider this very carefully before arriving at perhaps not entirely appropriate conclusions. You have comment something about the scrutiny. the organization has just gave us another 10 minutes, so I used them. But after 10 minutes will be cut, so we cannot go any further. So if I may, I would like to ask a final question, so to speak, to Arthur. Do you believe that, generally speaking, public entities feel more comfortable with the ICC? I have the same impression that Maria Claudia just told us, but just that's obviously just an impression. I'm not a public lawyer. So what do you think about this? Do you think ICC is perhaps due to scrutiny or due to other reasons better suited to deal with public cases in Brazil?
Well, thank you for your question. I think as I have showed in the chart and the other ongoing cases, most of our cases they end up in ICC. I think the review process, scrutiny, it's a very important thing, but maybe not the only thing. It's very important, and it's the biggest institutional, global institutional. But I think one thing that plays a really important role in this choice is, as I said, we have two types of litigators in arbitration against public entities. We have the Brazilian ones, and we have the international, the foreign investors, which controls Brazilian entities. And because of this last group, at least in the oil sector, this is a very big demand in these consultations that we did for international institutions to lead the disputes. On the other hand, from the Brazilian litigators, we have a demand for like reduced cost, small entities, small institutions to more cost-effective deal with this. So in our arbitration clause, after these consultations, we decided that if the parties can't agree, the parties may agree on an institution, but if they can't agree, it should be one of the three big international ones. But the thing is, among these big three maybe, ICC is the only one that has offices in Brazil, in São Paulo. So they conduct the cases. The cases are all in Portuguese. Of course, they have ICC in the other people who speak Portuguese, but to have these arbitrations conducted in Brazil, since all the parties are Brazilian, even if controlled by foreign investors, and to charge in local currency and everything. So we get the best of both worlds. We have arbitration conducted in Brazil, but with an international entity, which makes the foreign investors more comfortable. And I totally understand why they are more comfortable not litigating in Brazil in a national entity. So this balance makes all of our big arbitrations, they end up in ICC. Of course, this review the review process of the awards is very important to that as well.
Thank you, Arthur. I think it's safe to say at this juncture that the decision of the ICC to open an office here in Brazil was a very happy decision to everything. Obviously to us, Brazilian citizens, but generally speaking, it was a success. It is at this point, I think this is established already. And I think those reasons are very sound and understandable. So if other institutions, they want to have cases with the state to the same extent that at this juncture ICC has, they have to offer something in return, of course. We are already 5 minutes over our time. So I will just make a final remark. I think I'm entitled to as a moderator. And this remark aims to answer the very question that was asked at the beginning of our session, which is, with the rise of such an important player as a public entity most certainly is arbitration still the same game that it used to be? I perhaps should say that it's not the same game anymore. It's a more complex, but it's also more entertaining game. I would say that it is a must-see game. We all should stay tuned, but interesting things will come in the near future, I believe. So once again, in the name of ICC Brazil, I would like to thank very much ICC UK for this most generous opportunity, our panelists for sharing their knowledge with us, and the audience for its patience and kind attention. I'm looking forward to see everybody, hopefully in person, in the near future. Thank you very much.
Thank you, Cristiano, and thank you everyone for taking part. You've had some great comments on the live discussion, great panelists, and they've really enjoyed it. So well done. It's sad to come to an end of our 3-day event, but it's been quite a couple of 3 days. So hopefully everyone can watch the sessions. If you haven't seen them already, go onto the virtual platform. Also, we're going to be sending you an email shortly from Swapcard just with some feedback. This is the first time that we use the virtual platform, so our arbitration community was a bit of a test bed for us. You've all been fantastic and have been using it, having lots of meetings, making lots of connections, which you can still do after the event. So the sessions are available for up to 10 days after, and do use the attendees button to connect with people from all around the world. Now is your opportunity to network virtually with people that in even a physical environment you would never have been able to meet. So before we leave, thanks again everyone for taking part. Thank you to our panelists and to our moderator and ICC Brazil for all of their help. It's been great working with you, and hopefully we can do it again sometime. Take care and have a lovely weekend. Thank you. Bye.